Kia ora tātou everyone, and welcome to this edition of InFocus, a TLA podcast. I'm your host Michael Andrew, and each episode we will be sitting down and talking to an inspiring guest connected to the legal sector, listening to their stories as they share their experience, and in the process explore some of the significant work that is being done behind the scenes that impact the industry and our communities. Our guest today is Catherine Stewart, an employment law specialist and barrister with over 30 years' experience in litigation. Catherine, thanks so much for joining me today.
That's my pleasure. I really do feel passionately about employment law.
Yeah.
And I think I started off doing commercial and civil litigation, doing a grounding in those types of litigation, but I did a smattering of employment law. And early on I realised that was where my passion lay. I loved those cases, and so it really evolved from there.
Yeah.
And I specialised in due course in employment law, and I have done now. So for about 20 years, it's been my area of specialty. So
Brilliant.
I do feel very passionately about what I do. I think it's not only how much it means to me, but it's how much it means to the clients.
Yeah.
And that's the key issue. And I think we can't underestimate just the impact that the work that we do as lawyers and as barristers has on the lives of our clients.
Yeah.
And how important it is to resolve these disputes for them, because they really matter to our clients.
Yeah.
And I think I wanted to tell you a little anecdote about a client that I had
Please
a
do.
few years back, who was a senior member of her particular profession and had been stood down for alleged serious misconduct with the threat of dismissal. And I remember her saying to me the words, "My life is in your hands." And that really resonated and stuck with me as quite a heavy responsibility. But I think in the end we did resolve it, and she was very grateful. And I remember getting letters not only from her of gratitude, but from her entire extended family, who all wrote me letters of gratitude. And I think the point I'm making is that these disputes really do mean an awful lot to people, and that was possibly a bit of a hyperbole, saying my life is in your hands, but that's genuinely how she felt at the time, because the level of distress and conflict that she felt was that great, and she needed it to be resolved.
Yeah. What's that word, livelihood, right? Because that it has implications on someone's livelihood. It affects all manner of their lives, It's such an important part of the fabric of their entire life is their work.
It's a huge part of their work and their livelihood. That certainly carries connotations of their financial livelihood, but there's a broader aspect as well, which is their mana and their dignity and their sense of identity. And all of those things are also carried with the disputes. And I think when people get themselves into situations where their employment is lost or where there's a serious threat to their employment, it's not just the financial aspect that worries them, but it's the greater aspects of their dignity and their sense of identity. And so I think it really does matter to people, and we see that all the time in the disputes that we are brought in to resolve, because no one in their right mind would want to be a litigant. It's stressful, time-consuming, expensive, uncertain, filled with conflict. But yet people do it because what is at stake for them is even more important than those things. It really matters to them. They bring these issues to the table because in their world there is a wrong that needs to be righted. And so the work that we do really delves quite deeply into helping people overcome those huge issues in their lives and restore, hopefully, their financial world, but also their world of their dignity.
When did you come to realise this, when you first got into employment law, that it carried this gravity of importance on people's lives and on their working lives? At what point did you realise, hey, this is actually something I really want to do because it really matters and it really has value for the people affected?
Really from the very first case that I did, as I recall it, and from, most cases going forward, you do see that aspect of it when you're acting for employees. I do a mixture of acting for employers and employees, but when you act for employees in big cases where they're going to court, you see that all the time, where these are issues that matter a lot to people.
Yeah.
And our role is to be, I think it was Justice Stephen O'Meara from Australia who described it as the shepherd in your client's hour of need. And I do really like that.
Yeah.
And then he goes on to say we are their advisor and their avatar. So it's a lot more than just applying the law and saying this is what the section says.
Yeah.
It's about being there at a time that is of intense personal stress, often to people, and sometimes equally for employers. They also feel aggrieved or taken advantage of, or that there's been wrongs on them. So it's an intensely personal situation when people come to us and they have a problem that needs to go to litigation.
What's that feeling like when you successfully achieve an outcome that your client has been wanting, when you actually win a case, and the feeling of relief that they probably get? I imagine it's quite palpable for them, but as the lawyer representing them, what's that feeling like for you?
It was very satisfying and rewarding that you've been able to help someone to achieve their sense of justice. Very, very rewarding, and ultimately it sounds very cliched, but coming back to that concept of we are here to help people at the end of the day, and that's what we do. And it's much greater than what we're taught at law school, which is also incredibly valuable, but it's much greater than applying the law and applying the sections. It's about seeing a dispute through with a client who's under intense stress. And so it's very, very satisfying when you do get a good outcome for your clients and you see how relieved they are.
Yeah. That anecdote you referred to before with the client who said, my life is in your hands, was that a successful outcome?
Yes, it was. And she had her role restored, which meant a lot to her.
Yeah.
And so that, as I said, I got letters of gratitude from the whole extended family.
Yeah.
And that's how far that went with the family, that the sense of that, what they saw as an injustice being righted, was so deep within them that the gratitude was overwhelming for them. And I think we can never overestimate the stress that people go through in these situations, how much it affects them, how deeply troubled they are, how much their mental health is affected by the workplace conflict or by the workplace disputes.
Yeah.
And how difficult it is for them to see these things through.
Are there any particular cases that you've worked on that stand out to you as being the most satisfying or fulfilling in your career? Is there anything you look back on that really just jumps out as encapsulates the reason why you're doing what you do?
I think, without talking in specific detail about specific cases, I think the cases where the problems have been the greatest, such as the serious misconduct dismissals, where you know that the person is going to be without a career if we don't turn it around, those would be the most satisfying when you can get the outcome. And then, of course, the court cases where you get a result that is in your client's favour are also very rewarding. So some will settle out of court and some will need to go to court and fight it through the justice system. But I won't talk about any specific cases other than to say the ones where you feel that your client has been vindicated would be the ones where they would stand out for you.
And I suppose a lot of these disputes are going on for, in some cases, years, really extended periods of time, and that probably only adds to that sense of vindication once there's some kind of resolution found.
That's right. So it's very much like how long is a piece of string. Sometimes you can turn a case around and get a settlement within a week, and then sometimes you'll still be fighting it out through the court system for years, and that's quite soul-destroying for clients to have to go through such a lengthy process.
Yeah,
Yeah.
absolutely. You're obviously, when you're pulled into disputes, you are present a lot of the time in the Employment Relations Authority and the Employment Court where these disputes are playing out. I wanted to ask you, because as a journalist, I tend to find ERA determinations particularly hard to decipher as opposed to employment court determinations. Is this something you find, or is it just depending on the member who's writing the determination or who's presiding over the...
I don't find them hard to decipher. I think they're usually briefer and more to the point than the court decisions.
Oh, interesting, okay.
And that's usually because you usually go into a bit more detail
Yeah.
in the court. You're dealing with two very different types of specialist bodies. You're dealing in the Employment Relations Authority with an investigative process.
Yeah,
And so the member takes much greater control over the way that the hearing is conducted, or it's called an investigation, the way that's conducted, whereas in the courtroom it's more adversarial, and so you generally have a lot more process and cross-examination, and probably you're citing more legal principles and so on, and they're very different beasts, as it were.
Yeah.
And so the authority ones would usually be, we would expect them to be a little bit less detailed, but to have more of a pragmatic focus on resolving, whereas the court would tend to be more legalistic with a greater emphasis on precedent, as a general rule of thumb, but then there's always variations to that. But no, I think I can usually decipher the authority decisions.
There's probably a reason I can't do it very easily. That's interesting. Do you have a preferred arena in which you like to work, like the ERA or the Employment Court, or is it kind of just...
Well, I work with 4 fabulous staff barristers, and so I usually these days allow them the opportunities to appear before the Employment Relations Authority.
Yeah, fair enough.
Because it's generally at more of a junior level. It's more low level than legalistic.
Yep.
And they work really well in that forum, and then I usually take on the Employment Court work.
Yep, fair enough. That's a good division of labour.
Yeah, and we try and keep the Employment Relations Authority's matters, because it's more of an informal forum, it's more of a low-cost forum as well. So that tends to work quite well.
Yeah.
Yeah.
So at what point in a dispute do you tend to enter the picture? Because obviously a lot of these can go on for ages internally, where it's, between the HR manager and the plaintiff, as it were, and then maybe an advocate's brought in. But at what point are you engaged generally, and does it escalate to that higher level?
Well, it depends on what the client wants. But, often when clients come to us, they've tried different types of resolution already. So they've already been down the track of looking at trying to resolve it through HR, or possibly getting an advocate involved, or family and friends. It's been down the road often more than once in terms of attempts at resolution. And when it comes to us, it's usually because it's really entrenched.
Yeah.
It's got to the point where this is not just a kind of run-of-the-mill problem or dispute. It's parties who are really taking positional stances, who have very different views of the world on whatever the matters are. And often it's quite acrimonious, and often it's going to be very difficult to resolve those disputes without litigation.
Yeah.
And sometimes we can, but there is also a proportion of disputes where, for whatever reason, they're not going to settle, and they can't settle, and often the parties don't want them to settle because they're not issues which are able to be resolved by settlement. They need some kind of judicial intervention. So they're usually, the higher level of disputes by the time they get to us, and they're very difficult.
Yeah. You got to decipher and kind of untangle it all,
Untangle
right?
it.
Yeah, you're like an investigator going in, like a forensic investigator trying
Yeah.
to figure this whole thing out. Yeah.
Unraveling the situation and also having an early conversation with the client around what is their best outcome, what are they actually looking for. And that's always an interesting conversation to have right at the beginning, because understanding what they want to achieve might be quite different from what we thought they might want to achieve. And sometimes it's financial, sometimes it's vindication, sometimes it's a mixture, sometimes it's just about righting a wrong,
Yeah.
or being heard, or moving on, or being pragmatic, or whatever the outcome is. It's always variable, but finding a way for them to articulate that early on and understanding what they're really looking for, and then that informs our next steps. So when we get involved depends on really when the client chooses to engage us and what's happened before,
Yeah.
where they've come from.
Yeah. Okay. Let's go back to the very beginning for a second and how you actually got into law in the first place. Can you tell me a little bit about that process, and was it a premeditated decision, or did it just come to you over time?
Well, I got into law quite by accident, actually, because it was a careers afternoon at school which gave me the inspiration. Quite a fateful careers afternoon, because I remember going into this classroom and the teacher had set up brochures around the room with concepts on the front page of things that we liked doing or things that we were good at. Not the careers, just the things we liked doing or the things we were good at. And we had to go around the room and choose the brochure that best suited what we liked doing. And I found one, and it just looked as if it was perfect for me, because it had all the things that I loved. It had public speaking and English and writing and academic work and debating. And I thought, whatever that is, whatever that career is, that's the one for me. That's perfect.
Yeah.
And so I remember opening up the brochure and it said, you should be a litigation lawyer. And I thought, wow, I never thought of that. I always thought I was going to be a teacher. And now they're saying I should be a litigation lawyer. And so it was really from that moment on that I got that idea, and I never looked back. That was my total focus from that point on, and I loved that idea, and I worked to become a litigation lawyer. And I'm so pleased that I had that inspiration through that careers afternoon that gave me that thought, because I do love what I do, and I'm really pleased that that's the choice I made in my career.
Yeah, and that's quite early, I think. 14. You were 14 when you made that decision. That's some staying power you've got there, because I think a lot of teenagers oscillate and change on a whim. They get a fancy, like, oh, I want to be this, I want to be that. I certainly was like that. But
that's okay too.
Yeah. But
I mean,
it's good that you've kind of got that bout of inspiration and you've stayed with it.
Yes.
Yeah,
it is good. And possibly it's quite rare. I mean, people do oscillate, and that's okay too. They might take a while to work out. Some people don't work it out until they go to university, and they might try different things and see what works.
Well, not even then. Yeah.
But each to their own. But that was how I came across that idea of law, and it just fitted with who I am and what I want to do.
It says in your notes that you also enjoyed acting, and I'm seeing a trend here, because every person we've had on this podcast has been involved in performing arts in some ways.
Oh, right.
So that's an interesting,
that is interesting
dichotomy.
Yeah.
You've got actors and lawyers, which you might perceive as being polar opposite in terms of their, perception and kind of passions, but there's definitely a parallel running here, right?
I think there's quite a large crossover, because both are about conveying a message to an audience, albeit a completely different type of message.
Yeah.
With law, you're persuading in accordance with the law and the merits, but with acting, you are also assuming a certain character, and you're, persuading the audience that that's who you are. So I think there is a crossover, and I have always really enjoyed acting and always been involved in acting or producing plays and in debating.
You're still involved in?
No, not now, but I
Okay.
was for many years.
Yeah. Oh, great.
Yeah.
Okay, no, that's awesome. And so tell me a little bit about what you're doing these days outside of your employment law. You're currently the convener of the Employment Law Committee for the Law Association. What does that involve?
Well, we are a large group of senior employment law practitioners, and we have a wide variety of people who come from diverse backgrounds. We have lawyers who work for unions, and then we also have partners in large law firms, and we have a former member of the judiciary, and we have a university academic, we have publicly trading businesses or representatives. So we have a really wide variety of employment law experts from all fields, and we come together and discuss topical employment law matters and subjects. We discuss legislation, case law, we discuss matters of interest to the profession, to the jurisdiction, and we liaise with stakeholders. Regularly, we are very involved with discussions on proposed law reform. We regularly do submissions to Parliament on employment-related bills, and we have regular meetings with people who, for example, yesterday we met with the Ministry of Justice about proposed reform to the personal grievance regime. And that was a very vibrant debate with lots of ideas. And next week we're actually meeting with the Commissioners for the Royal Commission of COVID-19 on lessons learned from COVID-19. So we'll be bringing our thoughts to that discussion. A couple of weeks ago we went down to Parliament and met with the Minister of Workplace Relations. So we are very involved at the cutting edge of the law and what's happening. And we're a very vibrant committee.
Yeah. What does the personal grievances reform, what does that involve in terms of proposals? Is it quite significant changes needed?
Well, no decisions have been made, so the Ministry was at pains to tell us that and explain that to us, but they've put forward some concepts of what they describe as simplification of the personal grievance regime, and they're just debating ideas around whether they put an income threshold on the eligibility for people to raise personal grievances, or the other issue that they're looking at is around no-fault remedies, and whether if someone has a contribution to make in a personal grievance situation, they're not awarded any remedies. So those are quite complicated and complex issues that we put our views forward to the Ministry yesterday as part of a wider consultation that the Ministry is carrying out with a number of different businesses and stakeholders.
Yeah.
It's not at the stage of parliamentary reform or anything like that. It's merely just a Ministry consultation discussion. So we're very grateful to have the opportunity to be consulted on those issues.
So does it basically look like you and your fellow committee members getting together and just hashing out these issues? And is it like a structured debate where you each have turned, or you just all kind of battling it out?
Well, we're battling it out, but we do have a meeting beforehand in which we corral the views of people, and we often have a good debate and a lively discussion, and we remarkably do almost always end up with consensus on the key issues. We might have different viewpoints, or we might have different slants around certain things, but overall we do tend to find that bringing all our wisdom, collective wisdom together often does find a way of finding a consensus among us. And so we do prepare in the sense that we have a meeting first at which we debate the issues, and then we go and talk to the stakeholders about what our thoughts are, and everyone is able to quite openly give their views on that.
Yeah. It strikes me as risky if you're in your position to spread yourself too thinly and take on more work than you are able to do with the time available to you, plus these kind of extracurriculars, if you call them that.
Yeah.
What's your tip for balancing your workload? Because I guess when you know you're doing such important work, the temptation is there to always be at it and always be on the clock. So do you have any strategies for just, okay, I'm switching off, I can't take on this, I'll hand this over, I've got to focus on this extra thing, but I don't want to get burned out. What's your solution there?
I think that's a really good question, and not just for me, but for the whole profession, because I think we work at great pace and we work under high demands with strict timelines. But I, for myself, am quite stubborn about a work-life balance. And I think that it's really important to take time out for exercise and to recharge and to connect with family and friends. So I do make that a priority. And I do think that doing so makes me a better lawyer, and it means I get through more work, although that might seem sometimes counterintuitive to down tools and move away from it. But coming back to it, I personally feel refreshed after a break, and I think that that's a really important issue for our whole profession, to make sure that we don't burn out and we do recharge and manage that work-life balance. And it's not always easy with the demands that we have. But I'm also very fortunate that I have great people around me and great supportive team, both my staff and the Law Association. You know, they're working behind the scenes, doing a fantastic job, and other colleagues who are supportive and I know that I can rely on or have a laugh with. So it's all about working together and making sure that we're all managing and coping okay.
Yeah. I guess the reality too is when you're working with these clients who are in very stressful situations, they've got your number.
Yes.
And they're probably apt to call you when they're going through something or they're really having a bad time. And you got to probably, set
manage
some boundaries
that
too, because you can't spend your whole weekend or, early hours of the morning fielding calls. How do you navigate that side of things?
That's a really pertinent question, and it's not only their number that our number that they've got, they've also got our email address, and they can bombard you with emails. But I think explaining to clients at the outset that this is just going to be more expensive for them if they keep on with a very high intensive level of communication, and giving them the peace of mind that we do understand and we have got it and we are working to help them and we will do so. And I think it's really just about very good communication with people, really making them understand, helping them to understand that we're on their side, and contacting us 10 times a day isn't going to make more difference than contacting us once a day, because as long as we've got all the facts, we're on top of it and we know we've done this before, we know what we're doing. So it's always a little bit of a challenge, and we are dealing with very stressed people, but I think working with them, alongside them, and keeping lines of communication open are really important.
Yeah. During the whole COVID pandemic, that must have been so hectic for you, and having all those rapidly changing pieces of legislation. How did you navigate that? And was there a precedent? Have you dealt with a period of time before where there was such upheaval?
No, never anything like that. That was an extraordinary period of time. I'm sure it was for everybody in different ways. But for employment lawyers, there were periods of time when the regulations and the law was changing almost on a weekly basis, or new things were coming out sometimes by the day, and keeping on top of that was really challenging. And if there was consultation, then it was a very quick turnaround. We had to be really on our toes in order to have a voice on any of that. And that was just because of the extraordinary times that we were in the moving feast. But that was a particularly challenging time, and we're still seeing some COVID cases coming through even now. I mean, there's quite a long tail for that work, but it was also a matter of grappling with how to answer some of the questions which were all new and unprecedented. Questions in relation to the wage subsidy, for example, or the right to work if you were on lockdown, or whether you were suspended if you were on lockdown. All these questions which we were just deluged with at the time and was new to everybody. So we were all finding our way on what the answers were, and it took time for the cases to come through the authority and the court for those determinations to be made. So it was an extraordinary time full of challenges. And I think we can all look back on that and say, wow, didn't we do well to survive all of that?
Yeah. And I suppose you'll have a particularly vigorous debate when you and the committee get together to discuss the lessons of COVID-19. I imagine there'll be a lot of
I think employment lawyers are going to have quite a lot to say about that.
Yeah.
Because it did impact on us all, and it was everybody trying to grapple with the issues. But if we can go forward with more understanding of how it might look in future, I think that would be to everyone's benefit.
That's great. Thank you.
It's a pleasure.
Thanks so much for coming in and sharing with us. It's
Thank
so
you for
great.
the opportunity.
No worries. And it's so great to hear about your work, and it's really admirable and inspirational.
Wonderful. Thank you so much.
Thank you for tuning into this week's episode. Subscribe to InFocus, a TLA podcast on Spotify and Apple Podcasts. And if you'd like to connect with the Law Association, follow us on LinkedIn, Facebook, X or Instagram, or visit our website, thelawAssociation.nz. Mā te wā.